Hello and welcome to your APLH online training. My name is Anthony Milner. I've been a trainer for some time and I'm going to take you through everything you need to know for your APLH exams. The course is made up of 13 modules. These are Introduction, Licensing Objectives, Licensing Authorities, Personal Licenses, Premises Licenses, Designated Premises Supervisors or DPS, Temporary Events Notices, Protection of Children on Licensed Premises, Legal Rights and Responsibilities, Prohibitions and Exemptions, Powers and Enforcement, Unauthorized Licensable Activities, and Responsibilities in Alcohol Retailing. The Licensing Act came into force on the 24th of November 2005 and replaced the much older 1964 Act. The Act brought about a large number of changes in relation to the sale of alcohol, entertainment, and the ability to sell hot food and drink after 11 p.m. Personal license. A personal license is the license that allows the holder to sell or authorize the sale of alcohol. Premises license. This is granted to the venue itself and often comes with conditions attached. Club premises certificates. These are granted to venues where qualifying criteria are met and the sale of alcohol takes place. These sales are for members only and is not open to the general public. For example, private members clubs such as hockey clubs, rugby clubs, or members-only clubs. TENs, or temporary events notices, these are events that take place outside normal conditions at a licensed premises or at a premises that does not hold a license at all. The licensing objectives. When the law was set out, it included 4 licensing objectives. These are the prevention of crime and disorder, public safety, prevention of public nuisance, and protection of children from harm. Under the Act, there are 4 recognized licensable activities. These are retail sale of alcohol in a club premises, regulated entertainment, and late night refreshment. Retail sale of alcohol. Now, any premises that is selling alcohol will have to have a premises license. The license will show whether the venue itself can sell alcohol to people who are going to consume on-site, to people who are going to consume off-site, or whether people will consume both on and off-site. So some examples. Somebody who's consuming on-site would most likely be visiting a pub or club. Somebody who's consuming off-site would be visiting a shop to purchase alcohol to take away and drink at home. And a venue that's serving alcohol both on and off-site would be a restaurant with a takeaway service. Any venue that is selling alcohol will have to have a DPS or designated premises supervisor who needs to authorize the sale of the alcohol. This person will be named on the premises license itself. Supply of alcohol in clubs. What we're referring to here is private members clubs. This is where no sale of alcohol actually takes place because the people inside the venue, the members, already own that alcohol. In order to be granted a club premises certificate, the following criteria need to be met. The venue needs to be not operating for a profit. There needs to be membership criteria for all members and club rules. Some examples of club premises are working men's clubs, sports clubs, social clubs, and some British Legion clubs. As sales of alcohol actually don't take place inside, there's no need to have a DPS or personal license. Regulated entertainment. Now, this is an event that is providing entertainment to spectators and guests with the intention of making a profit. Following are some examples of regulated entertainment. Any exhibition of a film. Now, there is an exemption here if the film is being played in a school, for example. Performance of a play under certain conditions. For example, where the audience numbers are over 500 or the performance takes place between 11 p.m. and 8 a.m. Any boxing, wrestling, or mixed martial arts, whether inside or outside, is also covered. Indoor sporting events, where any of the following apply. Where audience numbers exceed 1,000 spectators, or the event itself takes place between 11 p.m. and 8 a.m. Performance of live music or recorded music under certain circumstances. The following would be exempt from this. If there's already a premises license in place, which already allows the sale of alcohol and consumption on site, the premises are open for the sale or supply of alcohol, any live music being performed between 8 a.m. and 11 p.m., and if the audience numbers do not exceed 500 people. Performance of a dance would be counted as regulated entertainment if the following apply. If the audience is greater than 500 people, or the performance takes place between 11 p.m. and 5 a.m. Whenever any of those activities take place for members and their guests, other than the exemptions mentioned, this becomes a licensable activity, even if there's no charge made. It's important to note that any unamplified music played between 8 a.m. and 11 p.m. will not be classed as regulated entertainment, and this doesn't matter how large the audience is. If different activities are taking place within the same premises with different audience members, we need to make sure that the premises is fully licensed for these events to take place and no limits are exceeded. Entertainment at private events may be licensable, but only if there's a charge made with a view of making a profit. Live music performed in the workplace, which is not licensed under the Licensing Act of 2003, would not be regarded as a provision of regulated entertainment. The exception to this rule is a venue that has a provision for late night refreshment. This is true as long as it's performed between the hours of 8 a.m. and 11 p.m. to no more than 500 people. Late night refreshment. Late night refreshment refers to the sale of hot food or hot drink between the hours of 11 p.m. and 5 a.m. Now this becomes a licensable activity, which means local authorities will have the power to regulate it. Although no alcohol is being sold, so that no DPS needs to be in place. Remember that as no sale of alcohol is taking place under these provisions, there will be no requirement for a personal license or any DPS to be in effect. Some examples would include takeaways, kebab shops, burger vans, and some restaurants. Licensing authorities. All licensing in England and Wales are dealt with by local councils. This includes London boroughs, district councils, and borough councils. The licensing authority will appoint a committee made up of elected councillors. These councillors will deal with all applications for personal licenses as well as premises licenses. A full committee is made up of 10 to 15 members. They will then appoint a subcommittee which is made up of 3 members who will deal with any contested or objected to license applications. There's also a licensing officer. This is somebody employed by the council who will deal with all the license applications that are not contested or objected to. The licensing officer will also deal with all admin in relation to the licensing applications, and they will also go out and inspect venues themselves. The licensing authority is also required to keep a public record of all notifications and applications made to them. As this is a public record, it is accessible either online or via appointment. Whenever an application receives an objection or is contested to, the licensing subcommittee will hold a hearing. Some examples of reasons to hold a hearing would be the police objecting to a personal license application, a premises application being objected to by local residents, a temporary events notice being objected to by environmental health, or a review of a premises license called for by trading standards. This could be as a result of a failed test purchase. A test purchase is something that takes place when the trading standards would send an underage person in to try and attempt to purchase alcohol from a premises licensed venue. During the hearing, the licensing subcommittee would hear from the objector and the applicant and then consider their decision. Once a decision has been made by the local authority's licensing hearing, anybody affected by that decision has a right to appeal. All appeals need to be made to the local magistrate's court within 21 days of the decision. These are normally made in writing. The licensing policy. The licensing authority will need to produce a licensing policy every 5 years. This document sets out how the authority will promote the licensing objectives. Applicants must review this policy before making any new applications to the licensing authority. Other matters included in the policy would include local policies such as saturation of businesses in the area. This would include too many of a certain type of licensed premises in the area, crime and disorder zones, as well as model conditions that should be followed in the application. When issuing their policy, the licensing authority must have regard for the Secretary of State's guidance on Licensing Act 2003. Personal licenses. A personal license is issued by the local licensing authority and allows the holder to sell or authorize the sale of alcohol so long as it's in line with the premises license of the venue as well. A license holder can only sell alcohol in accordance to the times and conditions set out on the premises license. A personal license is granted to an individual, and an individual can only hold one personal license. A personal license is granted indefinitely, in other words, it doesn't have an expiry date, and it can be granted even if you're not working on a licensed premises. In order to apply for your personal license, certain criteria need to be met. You must be over the age of 18, you must hold the accredited qualification, you must not have had your personal license revoked in the last 5 years, and you must have the eligibility to live and work in the UK. The application must be made to the relevant licensing authority where the applicant lives. Personal license applications. These applications are made up of several parts. The application itself, which needs to be signed by the personal license applicant. Disclosure of convictions declaration form signed by the applicant as well. The disclosure and barring services certificate, which is valid for 28 days. This is basically a criminal record check. 2 ID photographs, which need to be signed on the back to say it is a true likeness of the person applying. This needs to be completed by someone of standing in the community, such as a clergyman, local councilman, or a magistrate. It can also be completed by somebody with a professional background, such as a solicitor or doctor. And lastly, the application fee, which is payable to the authority. Relevant offences. On applying for a personal license, any relevant convictions must be declared to the authority. This includes foreign offences as defined under the Licensing Act 2003. Some examples of these are any licensing offence since 1964, firearms offences, some dishonest offences such as theft or deception, driving whilst under the influence of alcohol or drugs, certain violent offences, and some trading standards offences. Foreign offences. A foreign offence is similar to a relevant offence, it's just one that was committed outside of England and Wales. Some convictions become spent under the Rehabilitation of Offenders Act 1974 and should no longer be considered under part of the personal licence application. Unspent convictions will still appear on your criminal record. It's also important to ensure that no false statement is made in connection with your license application. This would be a criminal offence subject to a level 5 fine. A level 5 fine means it's unlimited. This could include a failure to include a relevant or foreign offence in the application, as well as giving out a false address. Who can object to a personal license application? Well, only the police can object to a personal license application if the first 4 criteria are met, i.e. candidate is over 18, holds accredited qualification, has a right to work in the UK, and has not forfeited their license in the last 5 years. If one or more of these criteria are not met, the licensing authority will simply not process the application and reject it. If the applicant contains a relevant offence, the licensing officer will simply hand this over to the licensing officer at the police, who will then consider raising an objection. The police will only raise an objection if they feel that granting the personal license would undermine the crime prevention objective of the Act. The police have 14 days to raise an objection, and they need to give reasons for raising their objection. Following an objection notice being received, the council may decide to hold a hearing to determine whether or not to grant the personal license. If the police fail to raise an objection, despite there being a relevant or foreign offence present in the application would simply just be processed and granted. Remember, after any licensing hearing, all parties have the right to appeal to the local magistrates within 21 days. Duties and responsibilities of a personal licence holder. A personal licence holder has the duty to notify the local authority where they issued their licence of any name change or address change. Failure to inform a local authority of a name change or address change is a criminal offence and is subject to a Level 2 fine of £500. A personal licence holder must produce their licence to either a police officer or an authorised officer from the licensing authority. This duty applies to any personal licence holder who is selling or authorising the sale of alcohol, and failure to produce this licence could result in a £500 Level 2 fine. If a personal licence holder is convicted of a relevant or foreign offence, it is up to the court to notify the local authority of the conviction and the sentencing. A personal licence holder would not be convicted of the mentioned offences if they had reasonable excuse. However, not knowing your obligations as a personal licence holder does not classify itself as reasonable excuse. It is up to the courts to determine what is reasonable. It's also important to note that driving whilst under the influence of drugs or alcohol could lead to your licence being suspended or revoked by the local authority. Suspension or forfeiture of a personal licence. If a personal licence holder is convicted of a relevant offence, the court may either suspend the licence for up to 6 months or an order for forfeiture of the licence may be passed. It's important to remember that if a licence is forfeited, then the application for a new personal licence can only be made after 5 years. Premises licenses. What is a premises license? A premises license is granted to a premises which would allow one or more licensable activities to take place. A premises doesn't have to refer to a physical building. It could refer to things such as movable structures, such as burger vans. It could refer to things such as vessels, for example, a riverboat or canal boat, or an open field for festivals. Once granted, the premises license is indefinite unless one of the following occurs. The license holder dies or the business becomes bankrupt, the license is revoked by the authority, or the license is formally surrendered to the authority. Who can apply for a premises license? A premises license can be applied for by anybody over the age of 18. However, it can also be applied for by any company or business. Most alcohol sales are alcohol sales by retail, and therefore they will require a designated premises supervisor to be in place as well. Examples where venues are not required to have a premises license. Alcohol sold by a brewery to a publican, alcohol sold by a distributor to the retail trade, alcohol sold by a cash and carry to a retailer, and alcohol sold to a premises user who has a temporary event notice in place. Wholesalers are required to register for AWRS through HMRC. Premises license application process. The premises license application needs to be lodged with the local authority where the premises will be based. This is made up of the application form, which could be electronic, the floor plan, and the licensing fee, which could vary from venue to venue. The applicant should also carry out any further risk assessments to make sure that they are complying with any specific requirements. This could include a fire risk assessment as well as a police risk assessment that may need to be completed. If completing the application electronically, only one application needs to be submitted to the authority. However, if completing a paper-based application, applications would also need to be sent to all the relevant authorities. Responsible authorities. Responsible authorities are defined under the Licensing Act of 2003. These are authorities that can comment or ask for a review of any application that has gone through. They can also apply for a review of a license under certain circumstances as well. Some examples of responsible authorities are a police licensing officer, Home Office immigration enforcement, fire officer, health and safety officer, environmental health officer, planning officer, child protection, trading standards, also known as weights and measures, primary care trust or local health board. A notice summarizing the application must be advertised in local press as well as on the premises themselves. This notice should include details of the premises, opening hours or operating hours of the premises, where the license application can be viewed, and contact details of the licensing authority. Once the application has been made, it will be held for 28 days before the licensing authority will consider the application. This gives time for anybody to raise any objections. Whenever a new application for a premises is made, all interested parties have the right to raise an objection or consideration. This includes responsible authorities. These objections must be relevant to the licensing objectives. They cannot be frivolous, i.e. not serious, or vexatious, i.e. based on business rivalries. Any representation made by a responsible authority will always be considered relevant. If no representations are received by the authority, then the license will be granted as per its application. This may include any conditions proposed by the applicant themselves. If any representations are received by the authority which they believe to be relevant, then they are likely to hold a licensing hearing. They'll hear both parties' sides and then retire to make their decision. Following a representation, the following options are available to the licensing subcommittee. Granting the license as per application, granting the license but with further conditions attached, license is granted but with certain activities excluded, perhaps excluding a DPS, or finally, license being fully rejected. Appeal process. As with all decisions made by a licensing subcommittee, all parties have a right to appeal their decision. All appeals must be made to the licensing authority's local magistrate within 21 days of a decision. At the time of the appeal, the magistrate's court could take any of the following actions. They could substitute a decision, dismiss the appeal, and therefore the original decision made by the subcommittee would stand, substitute the decision, i.e. change the decision that the subcommittee made. Magistrates also have the power to decide costs. In other words, who will pay for the court hearing and how much those costs will be. Major variation applications. A major variation application would be made by a premises license holder who would like to make a major change to a venue's license. These could include changes to the operating hours, adding licensable activities, or perhaps changing the building itself, like adding an extension. Making a major variation application, the application process would be similar to applying for a brand new license. The only difference being that you would send in the old existing license as part of that application. Minor variation applications. These are much simpler than the major variation applications and would include making small changes that would not have an adverse impact on the licensing objectives. Small changes could include removing unenforceable conditions or very minor alterations for the inside of the building. Operating schedule. An operating schedule will simply show how the business is planning to operate, and it should include the following: description and nature of the premises, licensable activities proposed, times when the licensable activities will take place, and the opening times of the premises to the public, details of the designated premises supervisor, and any steps that will be taken to promote the licensing objectives. If we use the protection of children from harm objective as an example here, if I was doing my application to the council for my premises license, I would have to show if I wanted children allowed on the premises, during what hours they would be allowed on the premises, what control measures I put in place, as well as any staff training that would be required to allow our staff to understand what forms of IDs they were allowed to accept and what measures were put in place to prevent the underage sale of alcohol to people under the age of 18. For the public nuisance objective, we would have to show what control measures we had in place to stop odors from escaping from a kitchen, for example, as well as what noise control measures we have in place as well. For the crime and disorder objective, we would need to say what areas of security we have. For example, do we have CCTV in effect, as well as door supervisors or any other measures we have in order to reduce crime inside our premises. For the public safety objective, we would need to consider things like outside lighting, evacuation plans, and training for staff in the event of evacuations, as well as alarms. Partnership working. A number of authorities all work together in order to promote the licensing objectives. For crime prevention, this could be the police. For noise pollution and illegal dumping of waste, this would be the environmental health. Trading standards would work towards ensuring that the promotion of underage sale prevention is enforced in the area. Community safety partnerships, these are there to help reduce crime and disorder in the area as well as substance misuse. Mandatory conditions. All licensed premises must comply with the mandatory conditions. These are: a DPS must be appointed and hold a personal license. Each sale must be made or authorized by a personal license holder. SIA licensed officers must be on site if required. These must be door supervisor license holders if working on a licensed premises where the sale of alcohol is for on-site consumption. Age verification policies must be in place, such as Challenge 25. This refers to anybody looking younger than 25 being challenged to show ID to prove that they're over 18. No low-cost alcohol to be sold. This is from the ban of low-cost alcohol from 2014. No irresponsible promotions. No dispensing alcohol directly into the mouth. Free tap water available to customers. And drinks in small measures must be available. Failure to comply with any mandatory condition is subject to an unlimited fine or up to 6 months in prison. Review of a premises license. A premises license can be reviewed if for some reason there's been problems at the venue and it has been determined that the licensing objectives have not been followed. This could be because of a noise nuisance or perhaps the persistent underage sale of alcohol. A license review is an opportunity for the licensing authority to hear from both sides, both the premises license holder as well as the authority who has requested the review. One of the responsible authorities can request a review of the premises license at any time. The review will take place as a hearing by the licensing subcommittee, and they could take any of the following actions. They could suspend the license for up to 3 months, add further conditions to the existing license, they could remove the DPS, remove certain licensable activities, or revoke the license entirely. As with all licensing hearings, there is the right for all parties to appeal the final decision to the local magistrates within 21 days. Display of the premises license. Once a license is issued, the authority will issue 2 documents. One will be the premises license in full, and the other will be a summary of the premises license. It is a requirement that the premises license summary should be displayed at all times in the premises. The full license must be also stored at the licensed premises and must be available for inspection from any of the statutory authorities or the licensing officer. Failure to be able to produce this could result in a level 2 fine of £500. The DPS, or Designated Premises Supervisor, is a single point of accountability within that premises. They should be easily identifiable to both the police and any other authority who wish to visit the site. It is the DPS's responsibility that the premises operate both within the law as well as within the confines of their own license agreement. They must carry out risk assessments, implement any measures that are resulted of those risk assessments, as well as make sure the operation of the venue is inside the law. They must also promote the licensing objectives. Only the police can object to the appointment of a DPS at a premises. The DPS does not have to be present at all times. They're still responsible for what goes on inside the licensed premises. That includes whatever staff do within that premises. There can only be one DPS per venue, and that DPS must hold a personal license. Temporary event notices. TENs. If an individual wants to run an event that is outside the normal operating hours of their premises, or perhaps they want to run an event at a premises that has no license, they can apply for a temporary events notice. The individual who makes the application is known as the premises user. Limitations of a temporary event notice. The number of attendees at any temporary event notice cannot be more than 499, and this includes staff. The number of TENs that are issued for a single premises can only equal 15 in a calendar year, and that's been in effect since January 2016. A TEN can last for a maximum of 168 hours at the same premises, and which is equivalent of 7 days. There also needs to be a 24-hour gap between temporary event notices held at the same premises by the same user. The total duration of temporary event notices cannot exceed 21 days per calendar year. Now, this means if you were to hold a 7-day event, you could only do that 3 times before running out of total days available in a calendar year. A personal license holder can hold up to 50 TENs in a calendar year, of which only 10 can be late. More information on late TENs will be covered shortly. A non-personal license holder can hold a maximum of 5 temporary event notices per year, where they cannot exceed 2 late TENs in that period. How is a temporary events notice submitted? A temporary events notice needs to be submitted to the local authority via a form. 2 forms would be submitted to the authority themselves, as well as a form to the police and a form to environmental health. These forms must be submitted 10 days prior to the start date of the temporary events notice. The premises user will have to give details of the number of people attending, the licensable activities that will be covered during the event, as well as the operating time of the event itself. If the application for a TEN is made electronically, then only one application needs to be made, which would be sent to the council, and the council would then forward it on to environmental health and the police. A late temporary events notice is a temporary events notice which is made with no less than 5 working days before the event. If you do this, you do risk having the event turned down by the council with no chance of a hearing or appeal. Who can object to a temporary events notice? Well, the police or environmental health can object to a temporary events notice if they believe it's going to undermine any of the licensing objectives. If an objection is received, the council will hold a hearing to determine whether or not they agree that the running of the temporary events notice could undermine one of the licensing objectives. The police or environmental health could also impose some restrictions and conditions on a temporary event notice application if they believe that would promote the licensing objectives. There is a right of appeal by both the police and the premises user to the decision made by the local authority. Duty to display a copy of the temporary events notice. Once the temporary events notice has been granted, the authority will send back one of the 2 copies which will be duly signed by the licensing officer. This notice must be produced when requested by either the police or the licensing officer. Failure to produce this on request could lead to a level 2 fine of £500. Protection of children. Offences. It's an offence to sell alcohol or knowingly allow the sale of alcohol to anybody under the age of 18. It's an offence for anyone under the age of 18 to attempt to buy alcohol, or anyone under the age of 18 to buy alcohol, or anyone over the age of 18 to attempt to buy alcohol or buy alcohol for someone who is under the age of 18. It's also an offence for an under 18-year-old to consume alcohol on a licensed premises, or for staff to knowingly allow that consumption to take place. If this does happen, the venue itself is liable to a level 5 fine. Consumption of alcohol by a 16 or 17-year-old in a licensed premises. There is one exception which can be used to allow an under 18-year-old to drink alcohol on a licensed premises. However, there must be certain rules that are followed for this to be allowed. 1. The young person must be 16 or 17 years old. They must consume beer, wine, or cider. It must be with a table meal, and it must be paid for by a responsible adult over the age of 18. The responsible adult must accompany the young person at the meal. And please note that bar snacks such as crisps or chips do not constitute a table meal. This rule is for consumption only. Persistent underage sales. A premises that sells alcohol to an under 18-year-old on 2 consecutive occasions within a 3-month period will be classified as persistently selling underage alcohol. This could lead to an unlimited fine or a suspension of the license for up to 3 months. As an alternative to prosecution, the premises license holder may choose to close their venue for 48 hours up to 2 weeks if they have the agreement of the police to do so. It's also an offense for an adult to send a person under the age of 18 to collect alcohol which has been ordered either over the telephone or online. Delivery of alcohol to an under 18-year-old. It is an offense to deliver alcohol to an under 18-year-old. However, no offense takes place if the under 18-year-old is either working at a licensed premises as part of work experience, for example, or the delivery takes place in their home residence. It is an offense for an under 18-year-old to sell alcohol on a licensed premises at any time, unless each sale is authorized by a responsible person. A responsible person is defined as the designated premises supervisor, the license holder, or anybody over the age of 18 who works at the premises who's authorized to make the decision. This does not apply in the event of a table meal where a young person may be a waiter or waitress who's supplying alcohol along with the food. Children on licensed premises. There are restrictions in place for all under 16s on licensed premises at any time. No unaccompanied child under the age of 16 is allowed on a licensed premises which is primarily used for the consumption of alcohol on site at any time. It's also an offense to allow a child under the age of 16 on a licensed premises primarily used for the consumption of alcohol between the hours of 12 midnight and 5 a.m. It is up to the premises license holder to determine whether or not children will be allowed on the premises at any given time. This will depend on the nature and style of the business and its suitability for children. If children are permitted on the premises, the premises license holder must detail in the operating procedures how they will protect these children from harm. If children are to be permitted on the site, it is down to the premises license holder to determine how they will protect these children from harm. This needs to be detailed in the operating schedule. Proof of age. It's up to all staff to exercise due diligence by asking for proof of age before allowing the sale of alcohol on licensed premises. It's also a mandatory condition that all venues have a suitable age verification policy in place. The following documents can be used as proof of age: citizen card, passports, or UK driver's license, or any other driver's license. Test purchasing. Test purchasing is carried out by either the police or trading standards, where they send a young person in to try and purchase alcohol from a licensed premises. It's important to note that no offense is committed by the under 18-year-old. If a premises was to fail a test purchase, one of two things could happen. Either a spot fine of £90 to the person who sold the alcohol, or alternatively, up to £5,000 could be issued as a fine to the venue if prosecuted through the courts. It's good practice that all staff are trained in underage sale prevention, as well as get refresher training every year. Challenge 21 or Challenge 25. These are schemes set up to help bar staff or any staff working in a licensed premises determine when they should ask somebody if they could see their ID. Challenge 25 or Challenge 21 simply means that if the person looks younger than 25 or 21, then the staff are encouraged to ask for proof that the person is over the age of 18. It does not mean that the person has to be over 25 in order to purchase alcohol. Age-restricted products. The following list specifies how old a person must be in order to purchase certain products. Aged 18 or over. Alcohol, cigarettes and tobacco products, fireworks, knives, blades and axes, solvents, lighter refills, lottery tickets and scratch cards. Age 16 and over, petrol, spray paints, energy drinks, party poppers. As shown on the certificate, movies and games. Due diligence defense. If a member of staff is charged with selling a person under the age of 18 alcohol, they can use the defense of due diligence if they had no reason to believe the person was under 18. This includes taking all reasonable steps, including asking for ID to show that they were over 18, and no reasonable person would suspect that this person would be under the age of 18. It's up to the court to determine what is seen as reasonable. The use of a refusals book can go a long way to showing that the staff are diligent. Every time a member of staff refuses service to an under 18-year-old, they would then notify it in the book and log it down, including signing their name and the date. Legal rights and responsibilities in licensed premises. Duty to prevent disorderly conduct on licensed premises. It is the duty of all members of staff, paid or unpaid, to stop disorderly conduct on licensed premises. This includes the license holder, the DPS, and any other member of staff. Drunk and disorderly behavior should not be allowed on the premises at any time. Duty to refuse service to a person who is already drunk. It is the duty of all staff to refuse service to a customer who is already drunk. It is also an offence to attempt to purchase alcohol for somebody who is already drunk. There are two possible penalties for this type of behavior. A police officer who is in uniform and present at time of the sale can issue a spot fine of £90. If prosecuted through the courts, a level 3 fine of £1,000 can be issued. Failure to leave a licensed premises. It is an offence for a person to remain on a licensed premises when they've been asked to leave. Any member of staff can ask a person to leave at any time from a licensed premises if they feel they are drunk and disorderly. If a person refuses to leave a licensed premises, they can face a fine of up to £200. Illegal drug activity. The Misuse of Drugs Act 1971 regulates the possession, supply and production of illegal drugs in the UK. It's common for drugs to be used on licensed premises. All staff must be vigilant and not turn a blind eye to drug use on their premises. It's very important that premises license holders operate a zero tolerance policy, as a result of allowing drugs to take place on a licensed premises can result in prosecution. Other ways illegal drug activity can be prevented are making sure that the venue is well lit, both inside and out, making sure that regular toilet checks are made, and any other area where drug activity could take place, employing SIA door supervisors who are properly registered and trained to do their job, and ensuring staff are well trained and know exactly what to look for when it comes to drug misuse, including paraphernalia that may be left behind after drug misuse has taken place. Staff should be discouraged from trying to deal with drug dealers themselves on the premises, and instead should contact the police immediately. Personal license holders who are convicted of allowing illegal drug activity to take place could also face a forfeiture of their license or a suspension of their license. Anti-violence strategies. The government's strategy, known as the Alcohol Harm Reduction Strategy, has been used to help prevent alcohol-related incidents in town centres and city centres. This includes things such as fines, antisocial behaviour orders, as well as exclusion orders. However, it's good practice that any potential violence on a licensed premises is dealt with both safely and efficiently by members of staff. This includes ensuring friendly and efficient service by staff, as well as training staff to look out for the warning signs that violence may be about to erupt. Where staff are legally required to refuse service, staff should always do so in a way that refers to their legal obligations rather than making it anything personal. Venues should also only run responsible promotions, and staff should be trained to remain calm and call the police if necessary in a violent situation. Prohibitions and exemptions in relation to licensable activities. Moving vehicles. Sales of alcohol from a vehicle can only be made if the vehicle is parked either temporarily or permanently. Sales of alcohol from a moving vehicle are strictly illegal. Premises prohibited from selling alcohol. Some premises are prohibited from selling alcohol at any time. These types of premises are motorway service stations. However, privately owned motorway service stations may be exempt from this, but these are more the exception to the rule. Garages, primarily used for the sale or repair of vehicles, or petrol stations, primarily used for the sale of petrol only. Many petrol stations now do have a retail shop attached to them, which with a DPS can be allowed to sell alcohol. Exempt premises. Some premises are exempt from having a premises license. These could include sales which take place on board an aircraft, hovercraft, or train whilst making a journey, aboard a boat or ferry on an international voyage, at an approved wharf, port, or airport, normally on the air side of the airport, at any royal palace, or at any premises occupied by the armed forces, or at any premises exempt on the grounds of national security. Powers and enforcement in relation to licensed premises. Closure orders, all licensed premises in an area. If there is an imminent expectation of public disorder, a police officer of superintendent rank or higher can apply to the magistrate to close all licensed premises in an area. This would include all licensed premises as well as any temporary events taking place during that time frame. The maximum time that the area can be closed for is 24 hours. Examples where this could take place could be sporting events, film premieres, or other specified events taking place in the area. Closure orders for specific premises. This can take place if there is disorder in a local premises itself. A police officer with inspector rank or higher can apply to a magistrate for a closure order for a specific premises. This order will last a maximum of 24 hours before the magistrates themselves can decide whether to extend that or allow the venue to reopen. Closure orders, environmental health. Under the Antisocial Behaviour Act of 2003, environmental health officers are given powers to close a premises for up to 24 hours. This can be due to noise nuisance that's taken place inside the venue and the venue has been asked to close. A closure order could also lead to a premises license being reviewed. In order to avoid this, the premises license holder can elect to close their venue voluntarily. Failing to comply with a closure order could lead to a fine of £20,000 and or 3 months in prison. Right of entry on a licensed premises. The police, as well as responsible authorities, have the right to enter and inspect any premises which is applied for a license. This includes any venue that is applied for a temporary events notice. The police or responsible authorities have the right to investigate any licensed premises where any licensable activities are taking place or about to take place. They may also check to see that any activities taking place are in accordance with the premises license that's in place. The police have the right to enter and search licensed premises where they believe any crimes are taking place. They do not need a search warrant in order to do this, and any obstruction could lead them to use reasonable force. HMRC have the right to enter as well as remove goods if they believe that any fraudulent evasion of duty has taken place. If entry is required at night, HMRC officers will be accompanied by the police. Unauthorized licensable activities. Licensable activities offences. It's an offence to undertake any licensable activity without the required license. This includes operating the venue outside of the hours permitted by the license, offering music and dancing when this does not include it on your license, or offering licensable activities at a completely unlicensed premises. It is also an offence to knowingly allow unlicensed licensable activities to take place. The maximum fine for this is an unlimited fine as well as up to 6 months in prison. Defence of due diligence. A person accused of the previous can have a defence of due diligence if any of the following are true. What happened was due to a mistake, it was outside of their control, or it was due to the actions of someone else. It must be shown that all due diligence and precautions were taken in order to avoid the offence being committed. It is for the courts to decide whether precautions were reasonable or not. It's also important to remember that if you knew about the offence being committed, the defence of due diligence cannot be used. Responsibilities in alcohol retailing. The legal definition of alcohol. Any drink that contains more than 0.5% of alcohol by ABV, alcohol by volume, requires a license to be sold. Strength of alcoholic drinks. The strength of an alcoholic drink is determined about how much alcohol is contained within the beverage. It is normally measured as an ABV, or alcohol by volume, and is shown as a percent. For example, beer is approximately 3 to 9% on average, wine approximately 9 to 16%, and most spirits are above 40%. Examples of typical alcohol values. Any drink that contains more than 1.2% of alcohol is required to have a label which shows the exact amount of alcohol as a percentage so that the customer knows how much alcohol is in the drink. Other important definitions. Alcohol-free. Any drink which contains 0.05% of alcohol is classified as alcohol-free and does not require a license to sell. Low alcohol is no greater than 1.2% ABV. Alcohol is 0.5 or greater percent ABV. Also, a single unit of alcohol is 10 milliliters or 8 grams maximum. To calculate the level of alcohol, you can use the following. Quantity of liquid in milliliters times ABV times 0.001. For example, 25 ml of whiskey at 40% ABV equals 25 times 40 times 0.001 would equal 1 unit. The effects of alcohol consumption on the body. It's the alcohol in the drink which makes it intoxicating. Drinking too much alcohol can affect the physical, emotional, and behavioral state of the drinker. For this reason, it's classified as a drug. When drunk sensibly and in moderation, alcohol is not normally a problem for the body. However, if drunk too quickly and too much, the body cannot process the alcohol fast enough and the person will become drunk. BAC. The term blood alcohol concentration refers to the amount of alcohol in the bloodstream at any time. Blood alcohol concentration is measured in milligrams of alcohol in milliliters of blood. A BAC of 80 milligrams in 100 milliliters of blood is the level above which it is illegal to drive. It takes an average of about 20 minutes after the last drink for the BAC to start to fall. Most alcohol is processed through the liver, and the body processes approximately 1 unit of alcohol per hour. As well as the amount of alcohol consumed, BAC can also depend on a few other factors. The size of the person. For example, a larger person will probably be able to consume more alcohol and show a lower BAC than that of a smaller person. Their gender. Females generally show a higher BAC for less alcohol drunk than their male counterparts. Food eaten. Somebody who's eaten food more recently is going to show a slightly lower BAC than somebody who's drunk alcohol on an empty stomach. The British Medical Director's advice and guidelines for alcohol consumption is 3 to 4 units per day with a maximum of 14 units per week. And this applies to both male and females. Binge drinking. Binge drinking is a common term used to define drinking excessive amounts of alcohol in a single session. Although there's no legal definition of binge drinking, what is commonly referred to as binge drinking is drinking any more than 3 times the daily recommended amount. Chronic drinking is where a person would continuously drink alcohol over an extended period of time, often drinking daily and drinking in excessive amounts. This can lead to long-term health conditions, including problems with liver as well as heart disease. Late night drinking. Local areas have been given powers to deal with local problems. The introduction of EMROs, or early morning alcohol restriction orders, is an example of this. EMROs allow licensing authorities to restrict the sale of alcohol between midnight and 6 a.m. Drinking banning orders. Drinking banning orders are similar to antisocial behavior orders. A DBO can be issued to anybody over the age of 16 who is disorderly or commits a crime whilst drunk. A fine of £2,500 can be issued to anybody in breach of a DBO. As part of a DBO, courts could recommend courses to show the implication of heavy drinking, as well as stopping a person from purchasing alcohol or entering a licensed premises. A DBO can last from 2 months to 2 years. Thanks a lot for attending your Get Licensed Award for Personal License Holders course. All the best for your exams.